Hi, thanks for coming to our Ask EFF, Meet EFF panel. I'm Jennifer Granick. I'm the Civil Liberties Director at EFF. And what we're going to do tonight, it's nice, we have kind of a manageable crowd here. So what we're going to do tonight is I'm going to introduce everybody. I'm going to talk a little bit about some of the cases we've been working on over the past year, just to give you guys some highlights. And at a kind of high level. And then what we're going to do is we're going to open it up for questions from you guys and try to answer your questions. So there's a microphone that's over there, and you'll be able to line up there and ask your question, and we'll do our best to answer it up until about 6:50, at which point I think we're all just going to call it quits. Just a couple of things. I'm going to talk with my colleague here, Matt Zimmerman, more in depth about hardware hacking and at a very geeky level about the DMCA exemptions we recently won for unlocking and jailbreaking and non-commercial videos. Thanks. We've been waiting for that rulemaking since November, and honestly, I was wondering what was taking them so long, and I'm so excited that they issued it right before DEFCON, so it's great. For people who are really interested in that, we're going to have a whole talk about that sort of stuff tomorrow at 10, yeah. I think. And then later on tonight, for people who are interested in movies or interested in surveillance in movies, my colleague Kevin Bankston, there towards the end, is going to be doing Big Brother on the big screen with Nikki Ozer from the ACLU, and that is at 8 o'clock, looking at surveillance in the movies. So that should be really fun also. Okay. You guys are here, I imagine, because you know what the Electronic Frontier Foundation is, but for those of you who don't, we are a civil liberties organization dedicated to protecting privacy and free speech online. We are a membership-funded organization, which means that what keeps me off the streets and fed are people like you who give us money, so we appreciate everybody who is a member. Now at DEFCON's a great time to become a member because we have a super cool shirt that has a blacklight kind of secret message in it, and you get access to our newsletter and all of that stuff. So if you are not now a member, then perhaps you might consider doing it here at the con. We focus on a whole variety of issues having to do with privacy, free speech, and consumer rights in the digital realm. And I'm going to just go through a few of these things today to kind of give people who are not that familiar with our work an idea, and also to evoke questions in your mind, and then we'll go forward and kind of turn the floor over some to you guys, and I will moderate. The first thing I want to talk about, of course, is something it seems like a lot of people here have already heard about, which are the DMCA rulemaking. And this is a triennial thing where Congress, having vaguely recognized that there's something deeply broken about the Digital Millennium Copyright Act, allows for rulemaking for exemptions to the anti-circumvention provisions of that law that allow people to do certain kinds of hacking. And in 2006, back when I was at Stanford, I got an exemption for phone unlocking to take your handset and put it onto a different network. And this year we kind of tried to press forward on some of the ideas that had engaged the Copyright Office in that rulemaking and try to go a little farther. So we asked for 3 exemptions, and we got 3 exemptions. We asked for the unlocking exemption to be renewed, and then we asked for an exemption for jailbreaking. In other words, to take your mobile handset and reconfigure it so that it can accept applications of your choosing. So what does this really mean? It's about mobile handsets and circumvention for using interoperability of apps, and we can talk a little bit more about that. And then finally, the third one for non-commercial video. You know, if anybody knows anything about the DMCA, it's really mind-blowing the Copyright Office decided to do anything nice for people who like to make fair uses and free speech uses of video, and so we're really proud of that one. In the privacy realm, we work both on issues having to do with the government and issues having to do with privacy versus companies. On the government side, my colleague Kevin Bankston at the end works very hard on sort of issues having to do with statutory privacy rights under the Electronic Communications Privacy Act and how to make that law better. And his project of digital due process puts us together with other civil liberties groups and companies trying to update and improve and strengthen the statutory rights that we have for communications privacy online. We do work with various companies, Facebook, Twitter, other companies trying to figure out how to help people be more safe about their information with those companies. And to that end, we have worked on a social network bill of rights that addresses both privacy and free speech issues. And everybody at EFF works on that sort of stuff, but I think Kurt Opsahl, who's my colleague right here, will be the person who will answer your questions if you have any issues about that sort of thing. Those of you who know me know that I do a lot of computer crime work, that I love and hate the computer crime statutes at the same time. And we've been doing a lot of work looking at how computer crime statutes have been used to kind of lock people into various services. So this year we have 2 cases actually involving the scope of the computer crime statutes and how they regulate what users do. One is our Facebook versus Power case involving Facebook's lawsuit against a data aggregator, in which one of the claims is that violating terms of service in order to do data aggregation breaks California's computer crime law. And another case, which is a criminal prosecution in New Jersey, United States versus Lawson, or I call it the Wise Guys case, where a group of people who called themselves the Wise Guys were purchasing tickets through automated fashion off of the Ticketmaster website and then reselling those tickets on the secondary market. So my colleague Marcia Hofmann, who's here sitting next to Kevin, if you have questions about those sorts of things, she'll probably be the one to answer those. We do a ton of work, as you guys all know, on intellectual property rights and free speech and innovation. One of the big things that we've been working on recently is this problem with these kind of copyright troll mass lawsuits against people where the rights holder of some or another sort, U.S. Copyright Group or some other, files a lawsuit against 5,000 unnamed does and then goes to subpoena from a provider like Comcast or Time Warner the identities of people with particular IP addresses who they think have been using BitTorrent or other peer-to-peer file sharing type software to download stuff. Yeah, well, are you booing the mass litigation or are you booing the downloading? Yeah, I mean to have a lawsuit against, I wasn't sure, but it was the timing was unclear to me. We have a lawsuit against 5,000 people as seeking their identifying information. It's like, how can you do that fairly so that people are notified, so that they're not wrapped up in a lawsuit that's improper, with a bunch of other people who they have absolutely nothing to do with. And Eva Galperin, who is our intake coordinator, who's sitting there on the end, helps us manage all of that stuff with all 5 or 6 or 10,000 of people out there who call us saying, I think that my IP address is being subpoenaed and I need to know what to do and I need your help. So, yeah. If any of you ever call EFF and you're looking for help, then you know about how great Eva is at trying to find people help, and how grateful we are for Eva to help us figure out how to give people assistance without talking to 5,000 people on the phone in a single day. Along the same lines of intellectual property and how it impacts privacy and speech, we have cases where we deal with claims of intellectual property infringement that impact on parody and other sorts of jokes like that. So I don't know how many people here know who the Yes Men are. So some people know. We have a case with a group that was doing a fake press conference parody of the United States Chamber of Commerce, and the United States Chamber of Commerce didn't think it was funny. So they sued this group, the Yes Men, saying that it was a violation of it infringed their trademark rights. And so you couldn't do this spoof parody thing of the Chamber of Commerce, so they're too precious. And sort of along similar lines, we have another case just involving anonymity and the right to free speech, where a gentleman claiming that he is the world's #1 hacker got some comments from people on the internet suggesting that perhaps not everyone agreed with that assessment of his skills. And there was something of a flame war over it, so he filed a lawsuit against a number of anonymous people, and has not yet, but seems to be poised to try to serve subpoenas to find out who it might be who disagreed with that contention. And so this is another example of how litigation is used to try to intimidate people through finding out who they are, and then subjecting them to lawsuits and that sort of thing. And it's very hard for people without any kind of organized resistance to protect yourself under these circumstances? How do you fight back? And that's one of the things that we think of as being an important thing that we can do, is not only to provide these sort of direct services people, to also to find a way to kind of disincentivize this misuse or abuse of the legal system. And to that end, not only in trying to get the court to do the right thing and the mass BitTorrent litigation stuff, like actually make them file separate lawsuits because these are separate incidents and that sort of thing. We have pushed for courts to award attorney's fees to the winning defendants if it turns out that the case was illegitimate, and that is one way that people can kind of push back, even though you can't afford lawyers or that sort of thing. It gives a real disincentive to plaintiffs who might otherwise abuse the legal process. So those are just some of the things that we've been working on this year. We have a bunch of other stuff we've worked on too. So if you have questions, or let me just go through and actually make sure I've said everybody's name, and then we're going to ask you to just line up at that microphone over there if you have questions, and we'll go through and just talk about the stuff that EFF does. So here I have Kurt Opsahl, right here sitting next to me, and then Matt Zimmerman, and Marcia Hofmann, and Kevin Bankston, and Eva Galperin. So, you guys, no questions? Well, we're all going to go home early today. There we go. Is that on? Okay. Say your question loud, and I'll rephrase it for the audience.
In your work, do you find that one political party does a better job of representing our interests than the other, or do we need to look at each political candidate individually?
Do any of you guys want to handle this question about the political parties?
Sure. Democrats talk a good game on privacy issues. Particularly candidate Senator Obama made a lot of promises about reforming the Patriot Act, reining in surveillance authority, greater transparency and accountability. I'm speaking on privacy issues. I'll leave it to others to talk about copyright or anything else. But it seems that those in power have pretty much the same opinions of the last people in power. And typically, regardless of who's been elected, the DOJ is the DOJ is the DOJ. And they will want the same things now that they wanted under President Bush and that they will want under the next president. And so, for example, just this week, there was news that broke that the Obama administration is pushing Congress to expand one of the most dangerous and worrisome surveillance powers that the Patriot Act expanded. These are national security letters, which are letters that are issued by individual FBI agents to get records about your communications, who you're communicating with, and how and when and how much, without any court oversight and with a gag order that disallows the provider from ever telling anyone that they were snooping in your records. They want to expand this power to go beyond just basic subscriber information like your name and address and billing information and such, and beyond phone records, which they've been allowed to get, to extend to any undefined electronic communication transactional records. This is the sort of thing we expected in the prior administration. It's the sort of thing we had hoped we would not see under the Obama administration, and yet there it is. And so I would say that disappointingly, we've found less of a difference than we'd like between the parties when it comes to surveillance issues.
Yeah. You want to say anything about that with regards to copyright? Or?
I think we...
Okay. Next question.
On the recent iPhone ruling, what exactly does it say that you can and can't do regarding jailbreaking?
Okay, great. So your question just gives me the occasion to say the disclaimer that I just wanted to say before, which is that we can't give you legal advice here in this forum, and you don't get attorney-client privilege with us in this forum. In other words, what you ask us, like if you're like, well, what if somebody had a bunch of cocaine in their car and it was parked outside the Riv, and don't do that, okay? So don't reveal stuff like that. And what we'll tell you is general legal information, but you can't consider it to be legal advice. That having been said, I can answer your question. The jailbreaking exemption says that you may circumvent technological protection measures in your mobile handset for the purpose of putting applications on the phone to make the phone interoperate with different applications. So, the ruling is not specifically about the iPhone, it's about any handset